So the word state in Article 12 is not the same as the word state in Article 3 or in Article 1. The word state in Article 3 or in Article 1 is province, whereas the word state in Article 12 is an entity against which a fundamental right is available. Say, as I was explaining to you with an example, that Devyani is locked in a room by me, can proceed against me to the High Court under Article 226 or to the Supreme Court under Article 32 for enforcement of our fundamental right, which I am violating? No. Why? Because I am not a state. But if any entity which is a state, say, which fits into the definition of the state in Article 12, does that with Devyani, she can very well file a writ either in the High Court under Article 226 or in the Supreme Court under Article 32. So these fundamental rights are primarily available against entities which fulfill the requirements of the definition of the word state in Article 12. So which are those criteria which must be fulfilled in order that an entity is a state against which fundamental rights are available? If you go through Article 12, we will find that any entity which is either the union executive, union legislature, state executive, state legislature, all local and other authorities. So union executive is the Prime Minister and his team. Union legislature is the Parliament. State executive is the Chief Minister and her team. State legislature is Vidhan Sabha, Vidhan Parishad. All local and other authorities. Local authorities are the corporations, municipal corporations, municipalities, panchayats, notified area, cantonment board. But then what is the meaning of the word other authorities? This word came up for interpretation before the various high courts and the Supreme Court in a plethora of cases. In Shantabai versus University of Madras, the Madras High Court interpreted the word other authorities ejusdem generis. Ejusdem generis means like others. So according to the Madras High Court, the word other authorities have to be interpreted in the light of local authorities. So authorities which are like the local authorities. As I have explained you earlier also with the help of an example, say if I tell you gold, silver and other metals. Now what does this term other metals stands for? If you apply the ejusdem generis rule, it is a restrictive interpretation and only precious metals are included within the word other authorities. But if you allow literal interpretation, then all metals except gold and silver are included. But the Supreme Court negated this contention of the Madras High Court, and in Airport Authority's case, the Supreme Court said that we cannot interpret the word other authorities ejusdem generis, because no restrictive interpretation will be allowed of the word other authorities in Article 12 in order to ensure that maximum people can take the benefit of the fundamental rights. Hence, according to the Supreme Court of India, in the various verdicts which the Apex Court, Honorable Apex Court has delivered, the word other authorities has to be construed liberally. Any instrumentality of the government is state which has the capacity of controlling the liberty of anyone by making rules. That is the test whether an entity can be called state or not. Like now, the universities, the government-sponsored colleges, schools, all are states. But then there are certain judgments in which even entities which for a layman or from common sense ought to be state were not declared to be state, like BCCI, like NCERT. Those judgments are a little different or wavered from the trend of the judgments of the court. So Article 12, the rationale of defining the word state in Article 12 is to ensure that fundamental rights, if violated by these entities, then one can approach the High Court or the Supreme Court for relief. Now let us come to Article 13. Article 13 embodies something which is implicit in the Constitution but not explicitly laid down. The term is judicial review. In a federal constitution, judicial review is one of the most striking features, which we all know was upheld by the United States Supreme Court in Marbury versus Madison. Article 13 does not explicitly mention the term judicial review, but then it mandates, it lays down that if any law violates or is in conflict with any of the provisions of Part 3 of the Constitution, it will be void to the extent of the inconsistency. Now, who declares whether a law is violative of Part 3 or not? It is the judiciary. It is the Supreme Court or the High Courts. So implicitly, the power of judicial review, one of the most important and striking features of a federal constitution, is contained in Article 13 of the Constitution of India. It also defines the word law. What is law? The term law, quote unquote, is attributed to acts, ordinances, rules, bylaws, circulars, and even to customs having the force of law. But a very interesting question came up for the consideration of the Supreme Court in many cases regarding whether constitutional amendment can be called law for the purposes of Article 13. And we all know that the Supreme Court has settled this forever, and it has been inserted by the Parliament also as a clause in Article 13 now, that constitutional amendment is not law for the purposes of Article 13. Because if it is considered to be law, Parliament loses the power to amend Part 3. And we all know that in Keswananda Bharati versus State of Kerala, Supreme Court has very nicely dealt with this and evolved the basic structure theory, which lays down that Parliament may amend any part of the Constitution, including Part 3, but it cannot touch the basic features. Thank you.